So good afternoon, everyone, and welcome to today's presentation on the SEC's guidance on cybersecurity disclosure and policies. Thanks to all of you who are attending here in person and by webinar. And before we get started, one quick housekeeping item. This is a CLE qualified course. We have a new sign-in sheet style. If you've been with us before, this is a little different. If you registered, your name has already been printed on here, so just go find your name and sign your signature next to it. If you did not pre-register, you can fill in your name and signature at the end. So please do that and pass it along the row so that everybody can sign in and get credit. So as you know, cybersecurity is a hot topic for public companies, actually for all companies and their in-house legal staffs, their IT staffs, definitely bubbling up to senior management and the boards of directors. And the SEC's recent guidance has stirred up a lot of discussion and raised some questions about this. And our goal today is to make sure that you walk away with a complete briefing of what the 2018 guidance says and what it doesn't say, what's new and what's not new, and what's required and what's simply encouraged. In addition, we want to give you some context for understanding the SEC's guidance. The SEC's guidance is just one piece of the puzzle. And so we want to ask the questions, what does this guidance mean in light of the quickly changing landscape for cybersecurity, trends in shareholder litigation and SEC enforcement actions, and developments in state, national, and international regulations? To help me cover that with you today are my partners and distinguished co-panelists, Kam Wong and Bob Cattanach. Kam and I are corporate lawyers who focus on advising public companies with regard to SEC filings and disclosures, as well as a wide range of compliance and corporate governance matters. Kam began her career here as an associate in Dorsey's corporate department and then served as senior counsel and associate secretary at General Mills for 10 years before returning to Dorsey. At General Mills, Kam had responsibilities for corporate governance and SEC compliance, securities offerings, M&A transactions, risk management, foundation governance, and general corporate and commercial matters. So Kam brings a very important point of view and a unique one of someone who has served both as in-house counsel and as outside legal advisor on issues facing public companies such as this one. Bob Cattanach, a partner in our trial department, brings the litigator's perspective to our panel today. Bob practices in the area of regulatory, cybersecurity, and privacy litigation, and also advises clients on privacy and information security compliance requirements, incident response, and international regulatory compliance. As a member of the Sedona Conference, Bob chaired the group that drafted what is becoming the definitive guide for responding to data breaches, and you'll find a link for that in your materials. Bob has joined me in the trenches in dealing with a number of real-life data breaches, and clients have found his advice to be invaluable. Before we dive into the nuts and bolts of the SEC guidance, and while you're still getting settled and trying to forget whatever it is you left back at the office, we want to give you a brief overview of the changing landscape of cybersecurity. We'll then dive into a walkthrough of the SEC guidance, both the disclosure piece and the policies piece. To provide context for the SEC's guidance, we'll turn next to a discussion of current developments in the areas of shareholder litigation, SEC enforcement actions, regulatory and legislative initiatives, and other matters that impact cybersecurity. Finally, we'll use the Equifax data breach as a case study to illustrate how the SEC's guidance might come into play in this broader context. So Bob, when you look at the cybersecurity landscape today, what do you see as kind of the big trends, the big picture trends?
Yeah, thanks, Gary. I mean, if you think about the world in which we live, the confluence of change in this space is mind-boggling. There's actually four different factors that are right now in such dynamic motion, it's hard to keep track. There's the technical side, right? Just the ability of hackers to access and take value from information. Sometimes it can be sophisticated ways of entry. Other times it's just there's the social engineering, and to trick someone to letting them in is really getting very polished. And then the cooperation among hackers on the dark web, they talk a lot. And one scheme begets another copycat scheme, and the next thing you know, it's covering the waterfront. It used to be more like snatch and grab, right? Somebody get in, they get out, take your stuff, and it's gone. Now these are criminal enterprises. These are people that get up and go to work at 8 in the morning, and they're at their terminal, and they're trying all day to figure out a way to get in. The human factor, though, is still something that we're all imperfect human beings, and no matter how hard we try, there will be mistakes made, and the training is terrific. People are getting much better about it, but the hackers typically are about one generation ahead of the defenders. They're very clever, and so they're finding continued ways to take advantage of human frailties. Couple that, so you've got the technical side, and then the Internet of Things. Everything is now increasingly connected, and one of the major technological advances of the hackers is they're really getting good at moving horizontally once they're in. So if they find the weakest link on the Internet of Things, and they'll move horizontally, and that creates an increasingly broad perimeter that we as individuals and that companies have to defend against. I think we're still seeing an evolution of this tension between the great convenience that the Internet of Things provides and then the challenge of maintaining security against that. And then on the other front, the regulatory and legislative initiatives, and we'll talk a little bit more detail about those in just a few minutes, those are changing on a daily basis. Many of you may have heard recently about the General Data Protection Regulation in the EU. That is having a trickle-down effect that I think people are amazed at how broad that effect has become. And then what we as individuals, shareholders in particular, have higher expectations of what companies will do to safeguard their systems and less tolerance for mistakes. And Equifax, which we'll talk about at the end, is just a case study in how things can go so horribly wrong. The lack of urgency in addressing what they knew was a serious vulnerability, coupled with an almost shocking insider trade before public disclosure, I think is going to be part of a game-changing dynamic. Couple that with Cambridge Analytica, and we haven't even begun to see the results of that yet, and for consequences. So there's much going on, and not surprisingly, the SEC is having something to say about it.
Yeah. So just to be clear, what you may or may not know is that there are no SEC rules or regulations that specifically address cybersecurity. So what we have from the SEC are two pieces of guidance. The first piece was issued in 2011, CF topic number 2, which is included in your materials. In the 2011 guidance, the staff of the Division of Corporate Finance was very upfront in acknowledging that the SEC does not specifically address cybersecurity risks or incidents, but the staff looked at the existing framework to address cybersecurity risks and disclosures. The guidance called specifically on the disclosure requirements that many of us are familiar with: risk factors, MD&A, the description of the company's business, the description of legal proceedings, the company's financial statements, and disclosure controls and procedures, as well as certain accounting standards such as ASC 250, accounting for loss contingencies, and said, you've got to talk about cybersecurity within this framework. In addition, the staff made it clear in the 2011 release that material information regarding cybersecurity risks and incidents is required to be disclosed when necessary in order to make other required disclosures not misleading. What emerged gradually following the 2011 guidance was, for most companies, a cybersecurity risk factor, many of which looked the same, somewhat boilerplate, and disclosures about actual breaches that were significant, but not much else. And then this past February, the SEC issued the second piece of guidance, which is also included in your materials. A couple of interesting points to note before we get into the substance. The 2018 guidance was issued by the Commission. The 5 commissioners issued this release, whereas the 2011 guidance was issued by the staff of the Division of Corporation Finance. And issues by the Commission, pronouncements by the Commission are generally given heightened importance. In addition, while the 5 commissioners were unanimous in approving the guidance, Commissioner Stein noted in a separate public statement that she was very disappointed that the staff didn't do more and that the Commission didn't do more, and she really was hoping that there'd be some kind of regulation SK amendment that would deal specifically with cybersecurity. SEC Chair Jay Clayton also made public statements, and he's asked the Division of Corporation Finance to look carefully at companies' public filings as part of their ongoing monitoring and review of 34 Act filings to see how companies are doing in response to this new guidance. And he said the SEC will continue to evaluate to see if further guidance is needed and possibly future rulemaking. There's also a much greater sense of urgency in the 2018 guidance than in the 2011 guidance. The very first sentence says that cybersecurity risks pose grave threats to investors, our capital markets, and our country. The release goes on to say that today, the importance of data management and technology to business is analogous to the importance of electricity and other forms of power in the past century. And given the frequency, magnitude, and costs of cybersecurity incidents, the Commission believes that it is critical that public companies take all required actions to inform investors about material cybersecurity risks in a timely fashion, including those companies that are subject to material cybersecurity risks but have not yet been a target. So a significant increase in the severity and urgency of the tone. In terms of the substance, the 2018 guidance can be broken down into 2 pieces. First, the disclosure piece. The 2018 guidance reinforces and expands on the staff's 2011 guidance relating to disclosure, but again, keeping within the existing disclosure framework. Second, and for the first time, the SEC addressed the need for public companies to have certain policies and procedures in place relating to cybersecurity. So Kam, can you take us through the disclosure guidance and tell us, did much really change since the 2011 guidance?
Thanks, Gary. So one way that the 2018 guidance expanded on 2011 was to provide a little bit more context on how to determine when a cybersecurity incident is material. And they cite a number of cases in the guidance, one of which is TSE Industries versus Northway, to say, is there a substantial likelihood that a reasonable investor would consider the information important in making an investment decision, or that the disclosure of the omitted information would have been viewed by the reasonable investor as having significantly altered the total mix of information available. They also go on to quote Basic v. Levinson. As part of a materiality analysis, a company should consider the indicated probability that an event will occur and the anticipated magnitude of the event. And so for those of you practicing in companies, this type of framework might sound a little familiar, and in fact, I think it's the marriage of governance and disclosure with the enterprise risk management process. A lot of companies have an ERM framework that takes into consideration both the magnitude of an event as well as its likelihood. And so I would see this as the Commission, giving companies a nudge. Hey, to the extent that cybersecurity is not an integral part of your ERM process right now, you should be looking at it. And furthermore, there are a number of facets to this risk analysis. And so companies should be considering not only, reputational risk and harm, but also financial performance, the damage to customer and vendor relationships as a result of a cybersecurity incident, and last but not least, definitely the possibility of litigation or regulatory investigations or actions. In the 2018 guidance, the SEC Commission goes on to emphasize several times that, in fact, omitted information can be material. That's something, we all know, just needed a reminder, apparently. And, there's no easy out here, so materiality is still a judgment call, so there's not a bright line, unlike some of the state law notification requirements that Bob will go on and explain later on. The Commission goes on to emphasize that technical and compromising information that may leave a company vulnerable to future breaches should not be disclosed, obviously. And Bill Hinman, in his congressional testimony recently, offered a friendly warning that indeed the SEC staff may be contacting company counsel for an analysis of why a breach was not material if the SEC were to see a news report that a hack has actually occurred.
That's kind of a big deal.
Yeah, it is. So, yeah, if you see that 212 number come up, I guess you better be picking it up. Which leads us to an issue that many of us have on our minds is, so say that there is a cybersecurity incident, how should we think about the timing of disclosure? So the 2018 guidance is very clear that an ongoing investigation is not a basis for delaying disclosure. And understandably, many of us working in companies and counseling companies, we're very wary of disclosing a breach until we understand the nature and the scope. Because there's obviously a fear of attracting negative attention and lawsuits. But the challenge for all of us is that these breaches evolve rapidly over time. And so I think that's what the SEC is facing, is doesn't want companies sitting on disclosure just because the magnitude of the risk and the damage could change over time. And so furthermore, I think a reason a lot of companies are considering disclosure sooner rather than later these days is because they know from painful examples we've seen, Equifax, Yahoo, that in hindsight, companies will face questions from regulators as well as the media as to how promptly they disclosed a breach. And the longer that companies wait, the more likelihood that there is that the ultimate issue becomes something they cannot control. So someone's going to leak the information, and then it's going to be someone else's version of the incident that's out on the front page news, that's out on newscasts. So going back to the 2018 guidance, another point that the SEC Commission was careful to make is that there should be fulsome disclosure prior to a securities offering, and that furthermore, companies should more readily consider the use of current reports to provide updates on cybersecurity incidents. And so, it's interesting, during Bill Hinman's testimony on Capitol Hill, it was pointed out that in 2017, only 3% of companies with major cyber breaches actually filed a Form 8K to disclose this incident, which is, pretty striking. The SEC clearly wants an upward trend there. And in fact, so I was looking through Equifax's SEC filings, and what we've seen since the announcement of the big breach is that there has been a steady stream of 8Ks with updates on how the investigation is going, and then most recently an 8K announcing a debt offering. So they were very sure that the investment community had as much information as possible about where the cyber breach investigation was before they announced this debt offering. Another interesting point on timing of disclosure was made in the 2018 guidance, which is, not only do companies have a duty to correct prior disclosure that they determine is untrue or where a material omission was made, companies may also have a duty to update the disclosure if it becomes materially inaccurate. And so the SEC based this duty to update and correct on Bachman versus Polaroid Corporation, but the commission acknowledges that other circuits have not found a duty to update. And furthermore, some of us may be scratching our heads just because it's a little counter to conventional wisdom prior to this. So the Private Securities Litigation Reform Act expressly disclaims any duty to update forward-looking statements. But the way we see this is the duty to correct and the duty to update, while it exists in tension with some existing case law and the PSLRA, it's really an acknowledgement of the realities and the challenges of cybersecurity incidents and how rapidly they evolve, and how information can quickly become not only outdated but misleading. The guidance also cites a case holding that there is no duty to update before the next quarterly report, so that's Higginbotham versus Baxter International. But I would view this as a general rule with some obvious exceptions. So, for example, in the guidance, the SEC talks about making sure you have current and up-to-date disclosure before you do a securities offering. So, obviously, if you have to put out a current report to do that, that's what you're going to have to do. So another area that us SEC disclosure lawyers will want to focus on for cybersecurity are the risk factors. And so in the 2018 guidance, the Commission lists a number of issues that companies should consider as they're looking to update their risk factors. And so we would really just encourage you to, take this list, and, it includes things like, prior incidents, probability of future events, adequacy of preventative actions. Take this list, put it against your current disclosure, and see if there's something in addition that you need to add that's material. And so to help you on that project, we've included in the materials a sample of risk factors that are keyed off of these items that the SEC is listed here. And it's worth noting that it may not necessarily be sufficient for a company that's had a previous material breach to disclose that simply there is risk of a breach. The SEC is going to expect to see a discussion of that prior incident. And we saw this observation echoed in the SEC's order in the Yahoo breach. Another watch out for annual and quarterly reporting is the MD&A. So there, really are there costs and consequences of not only prior incidents, but also risks of potential incidents that are worthy of analysis. And also, please consider the impact on each reportable segment, if it's applicable. Description of business, so that's something that shows up in the annual report. A cybersecurity incident could have an impact on products, services, relationships with customers or suppliers that is worthy of description. And of course, the section on legal proceedings may be worth a look because it does call for the disclosure of material pending legal proceedings and developments. And here, we're really watching also for the interplay between when and how we disclose for the SEC's purposes versus how other agencies' reporting requirements will come into play. And I was reading through Equifax's latest legal proceedings disclosure, and well, I guess I'd laugh, except I probably should cry. I mean, they're talking about not only the SEC reporting, but they're also talking about civil investigative demands by 49 state attorney general's offices, the District of Columbia, the FTC, the CFPB, DOJ, the list goes on. So it really is quite a, well, I don't want to call it a game, but it would be quite the project to coordinate all of the compliance and the disclosure, because there's been a huge explosion of regulation around disclosure and compliance when it comes to cybersecurity, and Bob's going to talk about that shortly. So moving on, financial statement disclosures. So, are there expenses, losses, claims, contingencies that we as attorneys should be discussing through with the company and also with auditors to disclose? And then finally, I'd like to move on to board risk oversight. And so here, once again, the proxy rules require a company to disclose the extent of the board's role in risk oversight generally. And so this is an opportunity to think about your company and your board's role in the enterprise risk management program. And to the extent that risks are material to a company's business, then it really should be included in the nature of the board oversight. And so, just a practice point, as we're considering next year's proxy, it seems like a very distant goal right now, but does the company, its board, and its enterprise risk management infrastructure have a way to involve the board in these determinations? If you're doing 3 lines of defense at the final line with audit, is the board and the audit committee somehow involved?
So with regard to the 2018 analysis, Cam, it seems like there's been, materiality is still the standard, and it was basically the black letter law reciting the cases we all know well as the touchstone there. Some interesting and somewhat controversial discussion about the duty to update. And then going through the various items that were in the 2011 guidance, MD&A, risk factors, legal proceedings, financial statements, description of business, enhanced disclosure in each of those areas, and kind of a checklist approach. So the SEC loves checklists. I would expect that as they're looking at our filings going forward, they're going to take out this release and they're going to have these checklists, and they're going to be looking for these items that we've laid out in these slides. So we would encourage you to do the same thing so that you can either have proper disclosure or be prepared to answer the question if you get a comment as to why you didn't make the disclosure. And the big new addition is the required disclosure under board risk oversight really does need to be included in your proxy statement. So start thinking about that now. board risk oversight is a requirement. It has to be in the proxy, and it now has to include discussion of cybersecurity. The new rules came out just prior to the proxy season, but they were kind of on the cusp, and many companies really didn't have a chance to react, and the SEC wasn't really expecting companies to react that quickly this proxy season, but it's a must-have for next season. The other immediate, in terms of what was new in the 2018 guidance, what was completely new was this new focus on policies and procedures. And I've listed each of them here, and I'll review them in some detail for you. But first, in terms of the company's disclosure policies, the company is encouraged to adopt comprehensive policies and procedures related to cybersecurity and assess their compliance for regularly, including controls and procedures. And the SEC guidance here did not name anything other than disclosure controls and procedures in terms of what types of policies they might be looking for. But we've listed here for you several very common types of policies. So if your company does not have policies that cover these topics, you should take a hard look at why not and consider developing them. Areas like network security and security governance, compliance, risk management, incident response, and business continuity sometimes can be wrapped up into one plan. Sometimes they're separate plans, but this is exactly where the rubber meets the road in terms of what do you do when you have a breach. And if you don't have a policy that you can quickly access and follow, it's going to look bad in hindsight. Second, companies are required already to establish and maintain appropriate disclosure controls and procedures. And the Exchange Act rules are cited here, but what's new here is that the 2018 guidance has added cybersecurity into this mix, and they're stating that controls and procedures should ensure that relevant information about cybersecurity risks and incidents are processed and bubble up through the appropriate personnel, including senior management and, in certain cases, the board, to make sure that the decisions about disclosure are being made, certifications can be made, and people can effectively monitor insider trading. So, again, pull out your disclosure controls and procedures and make sure that they capture cybersecurity matters as well as other matters. Third, insider trading policies and procedures came into the mix, and the guidance starts out by reminding us about the anti-fraud provisions that make insider trading unlawful, and then they encourage companies to make sure that they have policies and practices in place, whether it's their code of ethics or insider trading policies or both, to basically take into account and prevent trading on the basis of material non-public information. And this, of course, would include cybersecurity risks and incidents. The SEC stated affirmatively that they believe it's important that you have well-designed policies and procedures to prevent such trading. And they stated that while investigating and assessing significant cybersecurity incidents, you should consider whether and when it may be appropriate to implement restrictions on insider trading. See Equifax. So the obvious question for us is to make sure that you and our clients have insider trading policies and procedures, and if you do have them, to make sure that you've updated them recently. Some important items to consider are listed on this slide. They're also included in our Dorsey update, which is attached to the materials that you have, but there's kind of a checklist of things that you should be looking at in terms of who's covered, what's the role of your legal department, do you have a pre-clearance policy, do you have quarterly blackouts, do you have provisions for event-driven blackouts, do you talk about the use of 10b5-1 plans, who do you call if you have questions, and again, are you doing a reminder about this annually to your insiders and providing training? Finally, Regulation FD and selective disclosure policies hit the highlights here, and we haven't really heard much about these for quite a while. But here the SEC is bringing them to the forefront and saying they expect companies to have policies and practices to ensure that disclosure material inside information regarding cybersecurity risks are disclosed in a fair manner, not selectively, in accordance with Regulation FD. And again, interesting to note how Regulation FD and some of the state and foreign regulatory requirements interact, and we'll talk about that in a few minutes. So again, if you don't have a Reg FD policy, you should think about putting one in place. And if you do have one, you should think about dusting it off. Some things to consider are listed on this slide, but in terms of being comprehensive, make sure your protocol covers who's an authorized spokesperson and who is going to be monitoring this for compliance. Make sure that you've got annual trainings on this to your top management and other people that deal with the press and with the IR folks who deal with analysts and investors. Make sure your policy includes, as an example, a cybersecurity breach. And in terms of the role of the legal department, we want to make sure that they're involved to some extent here to make sure that items that are being reviewed for possible disclosure are either publicly disclosed prior to, if they're material prior to or immediately upon the disclosure to analysts and others who are covered by Regulation FD. So a whole new world in terms of policies. Those are the 4 areas that you need to focus on. And Bob, if we run afoul of these rules, what can we expect from shareholders and the SEC?
So as Gary and Kam have laid them out, the rules seem very straightforward. Makes sense, I get it, sure. Where things just fall apart is when you're in the middle of a breach. And Gary laughs because we've been there. And it never goes according to plan. And we'll talk about maybe some practical effects of how you have to marry up your policies and procedures with real life protocols when you have an incident. So a couple of truisms, you all know this, but it doesn't hurt to say it. In this day and age, any major cyber event is going to attract claims. There will be claims. The plaintiff's bar is getting very sophisticated. They're figuring out which theories work, which don't work, where they want to file. And that's coupled with a phenomenon that's fairly recent, really, which is the impact on the stock price of a breach. What's interesting is if you tried to connect the value of the information with the impact on the stock price, it's sometimes pretty hard to correlate. Holy smokes, we just lost $10 billion if you're Facebook. And I'm not too sure that information was worth $10 billion, but it's having a huge effect on stock prices sometimes. And so providing the legal context, initially shareholder derivative claims were tried when people were first litigating data breaches, didn't get very far in the courts. Kind of a high bar to clear. But that's changing with just garden variety securities fraud claims right now. I think the data point on here is really noteworthy. So we had none in 2016 securities fraud cases on data breach kinds of events. 9 were filed in 2017. We've already had several in 2018, including, and this one is really going to be interesting, the claim against Facebook for Cambridge Analytica. And the allegation is you didn't tell your shareholders that you weren't at all following what you were saying publicly. Just a quick digression, I think it was today one of the congressmen that was interrogating Zuckerberg said he just lied to me. He lied to me because he said people can control their own data, and they don't. That's the problem. And Facebook is probably, the poster child right now, but if you look at what people often say, your data is very important to us, we take it seriously, we try to protect it, and then you look at what happens when things go wrong, that commitment is kind of hard to make good on. So we've listed here some of the high-profile cases. I think Facebook is going to maybe eclipse them all by the time we're done. We're going to see some significant settlements out of this. And the $80 million settlement for the Yahoo shareholder class is nothing to sneeze at. And that's, that bar will not go down. That bar is only gonna go up. If somebody got 80 million for Yahoo, the next big one's gonna be 9 figures. So if we look at a couple of quick, Cam found these, and I think it's really telling. So this is the target situation, and I don't think there was a significant legal threat on a shareholder claim, because look at the stock. I mean, it didn't do that badly, and it's hard to say. Here's where it lost money. I mean, there's other ramifications, not good ones, but immediately after the breach, yeah, there was a little bit of a hit, but then the stock did quite well. Compare that then with Equifax. So Equifax, that took a hit and it did not bounce back. Facebook took a hit, it has not bounced back. So that's all you need. As a plaintiff's lawyer, Exhibit A, right? This is all you need. And yeah, no kidding. So here's, the SEC is trying to exercise some control, put some fear in folk. I mean, so they got a $35 million settlement with Yahoo, and one of the issues that people complained about was that was just a corporate settlement. There were no individuals, and if you look at some of the inside facts on that, it was like, how did they not string some guys up? Equifax, a different matter, of course. As you probably all know, one of their business unit CIOs, I mean, textbook insider trading, connects some docs inside, and we'll talk about this later. But it's really amazing what the insider did. So the SEC cyber unit chief, Cohen, you can read for yourself. He said, well, only when the facts are particularly bad and the conduct violates the statute very clearly. That's kind of a high bar, isn't it? So what the SEC, I think, is saying, it's not going to be our job to go out there and chase down every data breach, because they got the plaintiff's bar to do that. So what I think they're going to try to do is not bringing dozens of cases, but finding the right test case. Finding the right test case. And they're going to exercise their resources in that way. So the challenge that companies have when they have to deal with litigation, whether it's SEC or private party, is that there's no clear standard for what was reasonable care. And as a trial lawyer, this is the part that's the hardest, because the conduct of your client will be judged in hindsight. They can do 99 things totally correct, but none of those are going to make the poster board for the jury. It's the one thing that somebody has, we've got a problem, and it didn't quite get addressed. The history of all these breaches, I think, show that most of these companies actually did try to do a pretty good job, but that never, it doesn't matter, because it's the one that you didn't get right. We do have the hindsight test. So the Intel chip, as you're probably all familiar with, clear vulnerability in the product. Intel knew the risk. They had a sidebar with China to say, we have a problem here. They don't disclose it publicly. In subsequent public disclosures, I mean, that's a real tough situation. It wasn't exactly a data breach, but it gives an example. So the challenge, of course, is the longer you wait to disclose, the bigger the class gets, the longer the class period becomes. And so, again, what you try to do, and let's now bring to reality, you've got policies, procedures, et cetera. You got to practice them. We'll talk about that in a second, because you have to tell a story. If you have the unfortunate situation of getting an incident and it has consequences, somebody's going to have to tell a story. Here's what we did. We did the best we could. We tried. We had this procedure, the board got involved here, we did a tabletop exercise, whatever your story is, but you've got to be able to tell it, because otherwise, you're dead. You have to have some affirmative good story to tell you, how did we try to prepare for this? And one of the most difficult things will be explaining the delay between the initial discovery and later public disclosure. And the reason that happens all the time is because you're always dealing with imperfect information. You never, it's the fog of breach, right? Something's happened. You know something's happened. How bad is it? Well, the forensic consultants that we hire, the really good ones, might let you know in 30 days. Here's what we know. They'll tell you what got exfiltrated, how many records, what the magnitude is. So you can make a materiality call, typically, a confident materiality call, not that I'm an SEC lawyer, within a month. Doing it before then is really hard, because you don't know. I mean, they got to image the servers, and if you've got dozens or hundreds of servers, I mean, just the logistics of figuring it out is really challenging. So let's focus now on what happens if there is a breach. What do you need to do on the reporting? So the 50 states now, as of about 2 months ago, Alabama became the last state in the union to enact a breach notification law. You can go figure that out. But what triggers it, okay? The disclosure of personally identifiable information will trigger the disclosure notification requirements in every single state in the union. Now, once you get into that, you're going to see that it's different for not every single state, but many of the states. Some of the breach reporting obligations are in conflict. You can't send out the same letter and be in compliance. You have to have different letters. Now what's happening is the second generation of state activity on protecting personal data. Colorado, 2 days ago, just enacted a very aggressive statute that does several things, one of which is mandating protection of personal data. Very few states actually do that. Problem is, if you don't have that mandate, then there's frankly, not a lot of consequence right now, because it's difficult to show damages. That's evolving. Just as a pointer, in addition to just regular PII, there are separate regimes for disclosing personal health information, HIPAA, personal financial information, Graham-Leach-Bliley, and employee data is often overlooked as a source of potential exposure. So on top of this, we have, as I mentioned, state activity, but also it bears mentioning the GDPR is now it's been in effect for 10 days. And it is having consequences all over because there are lawsuits being filed throughout Europe. Every major tech company is being sued. And the law is still being defined. And many people think, well, I don't do business in Europe. I don't need people over there. I don't have to worry about that. Well, the way the GDPR is triggered is if you offer goods or services to EU residents, if you have a website, you're regulated by the GDPR, probably. And one of the dynamics we're seeing here is that the elevation of privacy as a fundamental right in Europe it's not viewed that way here in the U.S. But it is viewed as a fundamental right in Europe, and so the protections and the consequences for failing to protect are increasing, and those are not staying within the four corners of the European Union. One example, a very important example, we're going to talk about some of the challenges being faced. Maybe a year and a half ago now, the New York's Department of Financial Services has a cyber regulation that's very aggressive, mandates a lot of board involvement, specific board involvement in protecting cybersecurity, and it covers any financial institution doing business in New York. It's a lot of companies. And what we're now seeing is on the supply chain. Even if you're a small fish, your customers are saying, I want you to be GDPR compliant. I want you to comply with New York DFS regulations. And those can be challenging to do. So I'd like to talk just for a second about some of the conflicts now that we're headed for. If we had the next slide here. So maybe a little bit inside baseball, but I think it's worth looking at just for a second. GDPR says if there is a data incident, you have to report to the supervisory authority within 72 hours of discovery. 72 hours of discovery. Remember, the forensics take 30 days. And the only exception is unless it's unlikely to result in risk to the rights and freedoms of natural persons. So you have to prove a negative. So what a lot of consultants are telling companies right now, I don't think lawyers are telling this, but there's a lot of consultants in this space are saying, and I heard one say, if it goes bump in the night, report it. Well, I guess that's a safe thing to do, right? We'll just call them up. What happens? What's the cascade effect of that? So you've got a GDPR proving a negative. New York, 72 hours, but only if there is a reasonable likelihood of materially harming a security system. So you get to figure it out before you have the reporting obligation. Here's the problem. New York DFS also says you have to notify DFS if you report to any other government body. So in theory, you have an incident, you're covered by GDPR, you got 72 hours, and you, as a protective measure, you just tell your supervisory authority, whatever member state that will be in, but that triggers a reporting obligation to DFS, arguably under the way that the law works. And that is very problematic. Now, there is a confidential portal, I think, for DFS, if I recall correctly, Kam. So it may not trigger a public disclosure requirement yet. But then what do you do? And here's sort of the bottom line. You really need to be planning on this. You really need to have war game this, because at what point in time do we have a trading blackout? At what point in time do we have to disclose publicly? I mean, all of a sudden you've got levers being pulled in different jurisdictions, unrelated to materiality. And so then what do you do? Because the SEC, if it turns out to be a big deal, the SEC is going to say, well, you told DFS, you told GDPR, whatever. So watch this space. I will, one last plug, if you if you have a minute, take a look at that link to the Sedona Incident Response Guide. It's been peer reviewed, it's out for public comment right now. We had a great drafting team. Love to hear what you think about it. We have 2 more weeks of public comment. If you think it's good, that's nice. If you think if it's not good, or you think we need to do more or less, please feel free to put a comment into Sedona.
Okay. Thanks, Bob. Yeah, so this is the part of the lunch when we play through some of the issues we've discussed through an actual scenario, the Equifax case study, with both the benefit and the bias of hindsight. So as you know, a lot of us know, May through July of 2017, hackers were able to access personal information of nearly 44% of the US population on Equifax's servers. And then the security department of Equifax discovered this in July of 2017. They rapidly conclude, in fact, it is a material breach, but they don't know the full scope. So what happens then is management, interestingly enough, assembles 2 working teams. There's a breach response team consisting of security, legal, and IT personnel to address the breach. The team is subject to a special trading blackout, and they are clearly instructed not to share information on the breach with anyone outside the response team. The second response team is charged with designing a notification and remediation plan, but they are told it's for a client. They're not told about the data breach. They are not subject to the special trading blackout. And so let's pause here in the scenario, and I'm going to turn to Bob here. You know, just taking a step back. So are companies these days focused on preventing breaches or responding to them?
You know, I both, but you can't ever bat 1,000, right? So I think we're shifting resources to some degree. We've got firewalls, we've got detection systems. You're still gonna have an incident. So the plan, I think, important now is to have a plan and to practice the plan. and to have the stakeholders in the company, not just the IT department, but HR, all the way to communications. For publicly traded companies, this ought to be the C-suite that sits down with a plan to prepare to respond to a breach.
Yeah, I agree. We were just talking to an FBI enforcement agent recently, and he was saying, the companies on the front lines of this war, they're quickly shifting their resources to focus on disaster recovery and response. So let's go back to this case study. Question for both Gary and Bob. So assuming that the breach, it's unclear that whether or not it's material initially, how do you walk through a materiality determination when you're in the heat of the moment? There are just a lot of facts flying at you.
Yeah, that's really the tough question, because first of all, you have to get the forensics hired, and you want to do that through your lawyer for privilege purposes. So there's this process of involving the board and management and hiring the forensics people. The clock is ticking. When the forensics people come in, as Bob mentioned, it's a process, and the best forensics people in the world will take a long time. They'll be working around the clock. They'll parachute in a lot of people. They're really good at what they do, and then they'll go, well, we don't know. It's hard to tell. And then they'll work some more. Then they'll work some more and go, well, we found an infiltration. We found somebody broke in the barrier. Well, fine, but did they take anything? We don't know yet. So then they have to work on whether did they take anything, and if so, did they use it? So there's this whole rolling series of inquiries that are being made as the facts develop. And until you have a sense as to, an infiltration is obviously a red light, somebody broke in. But that in and of itself doesn't create a theft, and it doesn't create a notice requirement, and it's certainly not material from an SEC perspective. So, but you might have a GDPR notice requirement or a DFS notice requirement.
Yeah.
If you want to play it safe, you might want to notify those agencies, GDPR if you're subject to the EU, and then by virtue of that, arguably that triggers, the New York notification. So you're notifying some authorities of a breach, but you haven't told the public. Well, very important to make sure that your documentation around this process from the company's perspective is very clear, that you do not, in fact, believe that it's material at this time, that you don't have enough information for the sake of being conservative and complying with the important rules adopted by the EU and the state of New York. If you're subject to them, you are taking precautions and you are going to notify them on a confidential basis. But it is too early in the game to do anything from a materiality perspective in terms of SEC disclosures. Do you agree with that, Bob?
Yeah, I do. The New York DFS sort of materiality standard is yet to be determined. I don't think it's been litigated yet, so it's there in the books. You can read it. I don't know that it would rise to a materiality of an SEC requirement, but the word material's in there. Just one quick thought is, if you don't have an incident response plan, get one, and if you have one, practice it, because this is the kind of thing you're going to be wanting to think about ahead of the game. So, for example, records. The estimate now is it's a little over $200 per record that's been compromised. So if you say they got stuff, they got records on individuals, how many did they get? You do the math pretty quickly and decide, okay, well, maybe if it's 50, that's not material. If it's 50,000, probably is. So there are some benchmarks you can use on the materiality question to your point, Cam. And so but you can't do all of those contingency plannings in a document. It's best to have people in a room and war game it out.
Yeah, interesting. Thank you. So with the benefit of hindsight, look, there are these two separate employee populations, one subject to the special trading blackout, one isn't. Gary, if we were to do this over, how would you design the trading blackout here?
Well, I think, when they first discovered the breach of, 44% of the U.S. population involved, and they put management under a blackout, it seemed, it absolutely, I can't fathom why they didn't invoke a blackout for, company-wide. Nobody likes to do those because they raise speculation among employees. What's going on? Are we the subject of a takeover? rumors leak. There's some downsides to doing a full-scale blackout, but again, if you've told employees in the past that this might happen from time to time and you have a policy in place, it is by far the best thing to do, especially in this particular fact pattern. And then by virtue of bringing in a group under this ruse of doing a data breach analysis for a client was, I think, very ill-advised, to say the least. And certainly the CIO of that group that's being prosecuted right now by the SEC for insider trading would probably agree. He would have preferred to have been blacked out. So it's also, if you don't have a blackout, a full blackout, do your pre-clearance procedures go deep enough in the organization? Do you have them, first of all? Who's allowed to trade without pre-clearing it with the Secretary's office or the GC's office? That's a very standard provision in insider trading policies, and it should go deep enough in the organization to capture these people. So even if you didn't have a firm-wide blackout for all employees preventing them from trading, those within this pre-clearance group would have had to go to the general counsel or the secretary and say, I want to trade, can I do that? And they would have said no, because it's going to look bad because you're not aware of this, but there's something going on right now. So I think that's, again, 20/20 hindsight, but we get these kind of questions all the time about when to impose a blackout. It comes up in the context of M&A transactions, securities offerings, material developments of all types and sorts. And the analysis is always the same. Be conservative because 20/20 hindsight is perfect vision, and it looks bad for the company, the reputation of the company, the individuals involved, and there's real liability for the company and the individuals.
And then just to add to that, your incident response plan, I would suggest, is if they should have a scenario or a contingency. If a blackout is imposed, boy, that clock is ticking on when you have to make public disclosures or come to some finding, no, this is not material. Because imagine the scenario where, okay, if this doesn't go well, the fact that the blackout was imposed is probably going to be publicly disclosed at some point in time through discovery. And if a significant period of time expires between the blackout and the reporting, anybody that bought stock during that period of time would say, wait a second.
You've got public company and you've got state law disclosure requirements too. There's an FD overlay on all of this, isn't there? I mean, if you're sending out notices to hundreds of thousands of people about data, don't you have to make a public announcement, or are you just going to ride with non-materiality?
So the question for people on the webinar is, what's the FD overlay if you're giving notification of breaches? Again, here, notifying customers in and of itself is not a breach of regulation FD because they're not in the covered class, but the bigger question here is, how are you managing this disclosure? People are going to be getting these notices, and another common scenario is actually your hand gets forced because the press gets wind of this. And this happens a lot, actually. The company's going through this materiality analysis. The forensics are deep into the game. They're constantly talking, the company's constantly talking about their 50-state breach notification requirements. They're balancing the materiality against the probability. They're really trying to come up with good decisions, and then they get a call at 4 o'clock saying, we're releasing an article in 10 minutes about a breach at your company. Do you have anything to say about that? And boom, the cat's out of the bag at that point. Then it's very difficult to be in a no comment position on a claim like that. So again, your disclosure in that regard has to be formulated in advance. You need to have something ready to go, ready in the works to distribute to the extent that your hand is forced. And regulation FD obviously can be a problem, as Bryn mentioned. And there you're just going to have to, obviously you don't want to be disclosing to analysts and shareholders and investors and not to the public in general. And any disclosure made to a group, a large group, even if they're not investors or analysts or institutions, does bring into play this larger disclosure issue. If we've just made these people insiders, how is this information going to percolate, and are we able to manage, importantly, are we able to manage the message on the company's behalf? So that wraps up our discussion for today. Thank you all for coming. It's been great to have you here.